America loves a good lawsuit, big headlines, bigger payouts. Every day it's something new, a fresh case, a shocking verdict, a settlement no one saw coming. But here's the strange part. No one actually tells you how to file one. So, what happens the day it is your problem? When it's your name on that complaint? And suddenly, it's not just news anymore? This is not something you want to learn at the last minute. Before anything else, you need to know how the American legal system sorts its cases. Cases fall into two buckets, criminal and civil. Criminal cases are not filed by the public. The government files them through the U.S. Attorney's Office, working with law enforcement. So criminal cases remain outside the hands of ordinary citizens. Civil lawsuits are a different story. This is where every day Americans enter the legal system. The first question before filing any civil case is a simple one. State court or federal court? If your case involves federal law, it goes to federal court. Everything else usually heads to state court. This is a call your attorney makes. Even the state where your case is filed can make a difference, because every state has its own filing deadline. In legal terms, that is called the Statute of Limitations. Miss the window, and the case is over before it even begins. The actual process starts when the plaintiff, the person filing the lawsuit, submits a complaint to the trial court. This can be done online or by visiting the court, either by the plaintiff directly or through an attorney. The complaint lays out three things: what the damage is, how did the defendant cause it, and what you are asking the court to do about it. Whether it is monetary compensation or something else, you then need to pay a filing fee, which varies from court to court. Next, the court issues a summons. This is the official notice that tells the defendant they are being sued and includes a copy of the complaint. The summons must reach the defendant within 90 days of the lawsuit being filed. Once served, the defendant has a limited window to respond. Fail to respond, the plaintiff can win by default. No trial, no argument, just silence turning into judgment. If the defendant does respond, the case moves into discovery. This is where both sides gather evidence, take statements, and build their arguments. Before a trial even starts, many cases have already been settled. Once they do, the legal fight usually ends there. If no settlement happens, the trial begins. And it is the jury, not the judge, that decides how the story ends. If the verdict goes against you, the story does not have to stop there. You can take the case to a court of appeals. The appeals court will not retry the case. It will only examine whether the trial court made a legal mistake worth fixing. The process has never been simple. It was never designed to be. What should worry us is not how complex it is. It is how few Americans have never been taught any of this. Legal education has quietly gone missing from ordinary life, and most people only discover that the day they need it most. While you are watching this video, hundreds of lawsuits are being filed across America. Most of the people filing them had no idea how any of this worked a week ago. Now they are learning on the clock.